Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everybody. I speak to you on Saturday morning, November 2nd, 2024, very anxious. I've got 5 very complicated cases to get to, a 2-month-old in the background, and some San Diego waves that are asking to be surfed. So I guess I'll just say this. No matter what happens this week, you are alive, you are blessed more than you know, and you are very smart and capable. You're using your free time to listen to an immigration case law podcast, after all. In moments like this, though, I turn to the late, great Richard Lewis from the Shakespearean Mel Brooks drama, Robin Hood Men in Tights. Particularly apt here, explained Mr. Lewis as King John, quote, "Before the day is out, we shall have a wedding, or a hanging. Either way, we ought to have a lot of fun, huh?" Also remember, Robin Hood always wins, eventually. Here are the cases. Our first case is Farhane v. United States, published by the Second Circuit on October 31st, 2024. En banc. Y'all, 29 weeks ago I did this case on the pod, reaching back to August 2023, because it was a short week. Seems that I wasted my time, because the en banc court just reversed that episode 207 decision. This case is about ineffective assistance of counsel in the criminal context and denaturalization. As I said on episode 207, Mr. Farhane is a naturalized U.S. citizen born in Morocco, and as a U.S. citizen, he pled guilty to conspiring to commit money laundering. But in his plea allocation, quote, he stated that in 2001, he conspired to transfer money to mujahideen in Afghanistan and Chechnya, end quote. And that was just before he naturalized. Restated in his plea agreement, he admitted that he was committing criminal activity, and pretty bad criminal activity, before he became a U.S. citizen. He received a significant prison sentence. Upon his release in the midst of the Trump administration with its denaturalization task force, the U.S. government filed a complaint against him under U.S.C. Section 1451A, seeking to denaturalize him for illegally procuring his naturalization by concealment of a material fact or willful misrepresentation. Mr. Farhane, of course, did not tell USCIS that he was funding fundamentalist Islamic fighters in Afghanistan and Chechnya when he applied to naturalize or before his oath ceremony, or more importantly, about the money laundering to mujahideen. In pretty big trouble, Mr. Farhane filed a habeas petition in the Southern District of New York to vacate his conviction based on a claim of ineffective assistance of counsel. He claimed that his, quote, lawyer had not warned him of the risk of denaturalization and deportation before he pled guilty. End quote. The federal court denied the motion. A split Second Circuit affirmed the district court. At the time it said, quote, "Because civil denaturalization is a collateral and not a direct consequence of conviction, we agree that the Sixth Amendment does not require attorneys to warn of that risk." End quote. That is, denaturalization and then possible removal proceedings. But now, the full Second Circuit has remanded the case, with the dissent from before, Judge Carney, authorizing the majority opinion. It's a 97-page decision, so I shan't be reviewing the 2 concurrences and 3 dissents. But this will be good enough. After all, as I said on episode 207, if I may be so bold as to pat myself on the back, quote, and this is quoting me, how on earth does that square with the Supreme Court's Padilla v. Kentucky decision, which does indeed require criminal counsel to inform non-citizens of the potential removal risks, which of course is also collateral and civil, end quote. Indeed. Now I will begin reviewing this en banc decision. The en banc court held that, quote, the Sixth Amendment entitles a naturalized U.S. citizen facing the risk of deportation following denaturalization to no less protection than a non-citizen facing the risk of deportation. Deportation following denaturalization proceedings is a severe adverse immigration consequence that is covered by Padilla. To provide constitutionally effective advice, counsel must address the risk of this consequence with her naturalized citizen client before he decides to enter a guilty plea, end quote. The reason, explained the full Second Circuit, is because the Supreme Court's Padilla decision a decade ago, quote, disavowed, end quote, the strict framework whereby the right to effective assistance of counsel in criminal proceedings hinges on whether the misadvice relates to direct or collateral consequences of the plea. Rather, and at a minimum for immigration now, Padilla instructs that, quote, when permanent removal from the country was a possible consequence, the immigration result was too severe, its imposition too closely connected with the criminal process, and its effect upon families too drastic, to be lumped categorically together with other collateral consequences of a guilty plea, end quote. Query then why we don't have public defenders for removal proceedings. Query, I say. By the way, for purposes of ineffective assistance, affirmative misadvice is not required. Quote, silence on the subject breached the Sixth Amendment duty to advise, end quote. That is, silence on the fact that his plea could open Mr. Farhane up to denaturalization and possible removal. Some more facts about Mr. Farhane coming out of this en banc decision. Apparently he was trying to bring an ineffective assistance of claim very early on in his case, for what it's worth, but he ultimately spent 11 years in prison for his plea. Then, of course, denaturalization and all of that. So to be clear, quote, criminal defense attorneys have a Sixth Amendment obligation to inquire into and advise a naturalized citizen client of any risk of deportation following denaturalization proceedings that accompany the client's guilty plea, just as they do for a deportation risk facing a non-citizen client. If the plea carries such a risk and counsel has failed to address it, end quote, well, you have a basis for ineffective assistance and vacature of the conviction. In this case, it would appear that with the vacature of the conviction comes the facts that Mr. Farhane admitted to, meaning I suppose it can't all be a basis, at least not yet, to denaturalize him for withholding or misrepresenting something during the naturalization process, even though he admitted to it. Here are some more specific requirements. Quote, to provide effective representation, counsel must advise her client as to that paired set of serious adverse immigration consequences by at least flagging the risk. The risk of banishment may weigh more heavily in a criminal defendant's assessment of his options than any particular sentence of incarceration, end quote. To the extent removal is a collateral consequence because it's technically not the criminal punishment itself, and is therefore at least 1 or 2 steps removed from the criminal plea itself, denaturalization and removal is again, quote, particularly severe, end quote. And in any case, quote, a lack of clarity does not obviate the need for counsel to say something about the possibility of deportation, even though it will affect the scope and nature of counsel's advice, end quote. And that's from Padilla itself. Particularly here, whereas the Second Circuit explains the conviction is definitely an aggravated felony under I&A Section 11843D, a money laundering offense involving at least $10,000. The decision goes on and on and on, all pretty much based on Supreme Court precedent, with arguments that can be made in other circuits, rejecting a lot of the government's arguments. Heck, it looks like the judge who authored the panel opinion on episode 207 even came around to disagree with the original opinion, authoring a concurrence here. Lots and lots of dissent as well, but, Meaning, congratulations Naz Ahmad and Mudassar Tapa of the CLEAR Project from Main Street Legal Services at the SUNY School of Law, and a whole bunch of attorneys from Wilmer Hale, not to mention a whole bunch of amicuses. And there's more! So in this case, at the end, the matter was remanded for a proper ineffective assistance of counsel analysis under the Supreme Court's Strickland v. Washington test. Under that test specifically, quote, to establish that his counsel was constitutionally ineffective, Mr. Farhane must show that 1. Counsel's representation fell below an objective standard of reasonableness, and 2. Any deficiencies in counsel's performance were prejudicial to the defense, end quote. Seems like prong 1 is definitely going to be met here though, right? Else why go through like 100 pages of this? And so I'll just conclude by saying again what I said last time, even stronger now to be honest with you. If, as the Second Circuit explains, Padilla instructs that possible removal is so severe for a denaturalized citizen that a failure to advise of the possibility will likely result in an ineffective assistance of counsel claim under Strickland v. Washington, then why on earth aren't regular ineffective assistance claims in removal proceedings governed by Strickland v. Washington? I understand that it's a Fifth Amendment right in removal proceedings rather than Sixth Amendment, but I don't quite understand the distinction because it is all the same Constitution. So funny that you should ask, Kevin. Senator Murphy has introduced a bill in the Senate to make exactly such a thing a reality. That is, apply Strickland v. Washington in removal proceedings. Maybe call your senator and advocate for this bill to pass in the next term? I don't know how these things work. But I do know that the logic in this decision would appear to strongly support the senator's bill. And that is Farhane v. United States. Next is Matter of Khan, published by the BIA. Hello, BIA! This case is about criminal convictions and the categorical approach, meaning it is only good law if the circuit in which your removal proceedings take place has not said otherwise. Judge Science dissented. This case has been going on for a long time. Mr. Khan is a lawful permanent resident and in 2009 was convicted for gross vehicular manslaughter while intoxicated under Section 191.5b of California Penal Code, with a sentencing enhancement for fleeing the scene of an accident under Section 20001C of the California Vehicle Code. To be clear, Mr. Khan killed a pedestrian while driving drunk with his minor son in the car. After some back and forth with the BIA, and IJ held that the crime was a crime involving moral turpitude that I guess was committed within 5 years of Mr. Khan adjusting or being admitted, making him removable under I&A Section 237A2AI. DHS's burden, too. Now, importantly, but I'm sure correctly, Mr. Khan's counsel conceded that to convict, and to get the sentence received, the prosecution needed to prove, quote, the elements of both Section 191.5b and Section 20001c, end quote. But counsel argued, I'm sure correctly, that Section 191.5b lacks a culpable mental state, and Section 20001c lacks reprehensible conduct, as required to be a CIMT. And that makes sense, right? I'm sure you can get a conviction for being intoxicated and killing or injuring someone negligently, and then straight up fleeing the scene after an accident, or in this case, not complying after an accident, however innocuous, can be convicted under the 20001c conviction. But that's probably not base, vile, or depraved, that latter conduct in and of itself. And remember, quote, to involve moral turpitude, a crime requires two essential elements, a culpable mental state and reprehensible conduct, end quote. Because of the categorical approach, only the elements of the least culpable conduct required to convict are the focus of the analysis. Faced with these smart arguments, the BIA changed up criminal law a bit. It held that the IJ properly combined the elements of the Section 191.5b conviction with those of the Section 20001C enhancement to deem the whole thing morally turpitudinous. Kind of like a CIMT stew. In fairness, everyone relied on the Ninth Circuit's decision in Quintero-Cisneros v. Sessions, published in 2018, where it looks like the Ninth Circuit did a similar thing with the sexual assault of a child crime. And also in fairness, as the BIA block quotes in this decision, the BIA said something similar in matter of Martinez-Zapata out of 2007. I'm always fair, guys. So this rule, according to the BIA majority, quote, when the government must prove the elements of a sentencing enhancement beyond a reasonable doubt, those additional elements are combined with the elements of the underlying criminal statute, and all the elements are then considered together as one compound crime, end quote. Again, the criminal stew. That's what the majority saw as the interplay between Section 191.5b and Section 20001c here. Because of the enhancement to the BIA, the following elements needed to be shown to get the conviction and sentence that occurred here. 1. The defendant drove a vehicle under the influence of drugs or alcohol. While driving under the influence, the driver committed another infraction that might cause death. The infraction was committed in a negligent manner. The negligent conduct caused the death of another person. The driver knew that he or she had been involved in an accident that injured another person. And the driver willfully fled the scene of the accident. To paraphrase the BIA's very long description of the elements. To the BIA majority, this was necessarily turpitudinous. The majority rejected respondents' arguments that it must silo the elements of the actual crime and the enhancement from one another under the categorical approach. In part, this is because, quote, the sentencing enhancement under Section 20001C is not a standalone separate offense, and it is only triggered upon the commission of the predicate offense from which it flows. It cannot be charged on its own, but instead provides additional elements to be proven for the overall offense, end quote. So is that the requirement, right? You're not combining two convictions, it would seem. This is only the case for enhancements that can't be charged as standalones. To me. Still a tough sell on mens rea, though. After all, the really bad stuff, driving drunk and hitting someone, only require a negligent mens rea. Probably not a culpable enough mental state to be a CIMT under current law. But the Section 20001C enhancement requires knowledge that the person was injured and a willful act of flight, sufficiently culpable to the BIA when combined. To find so, the panel extended a bit Quintero-Cisneros. Not to mention that in Marmolejo Campos v. Holder from 2009, quote, the Ninth Circuit upheld the BIA's conclusion that a simple offense for DUI did not involve moral turpitude, but that moral turpitude inhered in the aggravated DUI conviction in that case because of the added element that the driver, knowing he or she was not allowed to drive, drove anyway, end quote. Even where that aggravation was simply, again, knowing that you were driving without a license. As to reprehensibility, to the extent that's a word, quote, knowingly and willfully fleeing the scene after being involved in an accident causing injury to another person is inherently reprehensible conduct, end quote. Again, combining the elements to get the proper mental state for CIMT. And I don't necessarily disagree here, but then again, what really is the standard for this whole reprehensible conduct requirement? Seems to be whatever the courts want it to be, but that's just me. To the majority panel's credit, they address this concern, but I don't know, seems to only support the unconstitutional ambiguity of the CIMT definition. Quote, moral turpitude does not arise simply from an amalgamation of distinct separate offenses, but from building together of elements by which the criminalized conduct deviates further and further from the private and social duties that persons owe to one another and to society in general, end quote. So advise your client of that standard. Some more arguments rejected, but that's the gist of the categorical approach stuff. So he's removable. The BIA majority then went on to explain that Mr. Khan was not eligible for a Section 212H waiver of inadmissibility. Can't apply for a Section 212H waiver by itself, explained the BIA. Can't do a standalone. It has to be in conjunction with an admission application from abroad or a readjustment of status in the United States, and it appears that Mr. Khan never applied to readjust status. Unsure if he still had a petitioner to do so, but it seems he probably did. Unclear. The BIA also affirmed denial of LPR cancellation of removal, which requires, among other things, proof of continuous residence in the United States for at least 7 years after being admitted in any status. Mr. Khan had 6 years and 8 months as a non-immigrant, but then lived abroad for 3 years and 4 months, and then returned as an LPR. He committed his crime 7 months later, thereby stopping accrual of his continuous residence under the law. Man, this case is a bit of a law school exam. You can't combine the years, apparently, and the 3-year period in between his 2 residences in the United States stopped accrual of continuous physical residence. With such a long time in between residences, quote, the respondent's intent to return to the United States was insufficient to overcome these facts alongside his lengthy absence, end quote. It all meant that Mr. Khan lost and the removal order was affirmed. And, to be fair, a seemingly well-reasoned decision in a complicated matter. What say you, Appellate Immigration Judge Saenz? Appellate I.J. Saenz begins that, quote, this case presents a complex set of criminal statutes raising difficult questions, and I appreciate the majority's detailed analysis, end quote. Appellate I.J. Saenz, however, doesn't think you should be combining the mens rea from fleeing to the actus reus of what's really the serious offense here, the negligently driving drunk and injuring or killing someone. Appellate I.J. Saenz explains why a lot of the Ninth Circuit precedent relied upon is distinguishable, and doesn't believe that prior BIA precedent is overly helpful either to the government's position, considering that here the enhancement is based on something that happened after the crime in chief, not simultaneously, right? Fleeing after injury. Citing BIA precedent in support, Appellate I.J. Saenz does not, quote, find that when the 2 acts at issue happen one after the other, a CIMT is created, even if we are permitted to stack or layer both acts under the formal heading of a single enhanced conviction, end quote. Recognizing the seriousness of the offense, but also the categorical approach's requirements, Appellate I.J. Saenz would grant Mr. Khan's motion to terminate. And that is matter of Khan. If you needed a mental break this week, you came to the wrong show. Next is Diaz-Arellano v. U.S. Attorney General, published by the 11th Circuit on October 29, 2024. This case is about cancellation of removal and the problem of qualifying relatives aging out. Judge Wilson dissented. Mr. Diaz-Arellano is from Mexico and has lived in the United States since 1989 after entering the U.S. without inspection and admission or parole. He was placed in removal proceedings 28 years later, in 2017. By that time, Mr. Diaz-Arellano had raised at least one U.S. citizen child, a daughter who was 20 years old. As Mr. Diaz-Arellano entered without authorization and the law changed in 1997, the only relief he was eligible for was non-LPR cancellation of removal. Pretty difficult to get, and at a minimum, requires a U.S. citizen or LPR spouse, parent, or child under the age of 21 years old. Mr. Diaz-Arellano's 20-year-old daughter was his only possible qualifying relative, meaning by her next birthday, Mr. Diaz-Arellano wouldn't have a qualifying relative. Everyone, of course, realized this in removal proceedings. In fact, the IJ, quote, offered to schedule an individual hearing on his yet-to-be-filed application. Mr. Diaz-Arellano, for whatever reason, declined, end quote. When he applied 2 months later, the IJ then set a hearing date that was after the daughter turned 21. Seemingly the only date then available? Unclear, but neither Mr. Diaz-Arellano nor his attorney objected to this pretty stark issue. But maybe that's why, a few weeks before the hearing, Mr. Diaz-Arellano moved for a continuance so that he could apply to adjust to LPR status through his U.S. citizen daughter, who was now over 21 years old and could petition for him. Simply devastating mistake, though, if that was strategic, because without an inspection or admission into the United States, Mr. Diaz-Arellano cannot adjust LPR status, irrespective of the fact that, yes, his daughter can file and have approved an I-130 petition for him. And IJ denied the continuance motion for that reason, and then Mr. Diaz-Arellano conceded that he was no longer eligible for non-LPR cancellation. As such, the IJ ordered Mr. Diaz-Arellano removed. The BIA affirmed, relying on its precedent in 2012 in matter of Isidro Zamorano. which holds that a child who was under 21 when her parent applied for cancellation, but who has aged out by the time the application is adjudicated, does not qualify as a child under the cancellation of removal statute. And the 11th Circuit affirmed that. It's statutorily based. The term child is defined in I&A Section 101B1 as a, quote, unmarried person under 21 years of age, end quote. But what to do with matter of Isidro Zamorano now that Chevron deference is gone? Well, to the 11th Circuit, quote, we exercise our independent judgment in considering whether the BIA acted within its statutory authority when it affirmed Mr. Diaz-Arellano's daughter was not a qualifying child for purposes of cancellation of removal, end quote. Sounds like Skidmore deference to me. But ultimately, explained the 11th Circuit, Chevron and all of that is irrelevant because it reads the cancellation of removal statute as unambiguously foreclosing the argument. To the court, the statute requires that a non-citizen, quote, have a qualifying relative when the immigration court finalizes its decision on the application for cancellation of removal, end quote. Then again, explains the 11th Circuit majority, quote, we note that this present tense determination will cut both ways. Babies will be born, couples will marry, and immigration judges may, in fact, must consider hardship to these newly qualifying relatives. So although children can age out when removal proceedings take months or years to schedule, those delays can work in an applicant's favor, too, end quote. Good point. Congress has made clear when it intends its statute to freeze a child's age for immigration purposes, explained the panel. CEG, the Child Status Protection Act of 2012. Another good point. And not done for non-LPR cancellation of removal. The 11th Circuit majority concludes by stating, quote, immigration law can often seem, and indeed sometimes is, harsh, but relief for parents whose removal would cause their U.S. citizen children extreme hardship is one mercy. Here, no child will suffer such hardship, so relief is not available, end quote. Judge Wilson dissented, believing that the non-LPR cancellation statute, quote, focuses on what the applicant establishes when submitting their application rather than what the court considers when reviewing the application, end quote, thereby saving the daughter from aging out in this case. But that did not win the day, and Mr. Diaz-Arellano lost his case. I've got more. So the 11th Circuit here has tethered non-LPR cancellation qualifying relative age out to when the IJ, quote, finalizes, end quote, its decision. Does that include the 3 to 4 year delay in finalizing cancellation of removal grants due to the statutory cap-created backlog? It would seem so. And then what if DHS appeals? Non-detained BIA appeals are taking years, possibly as many as 4. I truly am not sure what the effect of a BIA appeal would be, but I know that at least the agency decision is not final until the BIA rules. Are we really saying that a non-LPR cancellation applicant who establishes the requisite hardship to, say, a 14-year-old child might actually lose the opportunity to receive the relief due to cap and BIA appeal delays? I'm not sure, and in fairness, I haven't read the BIA's decision from 12 years ago in a long time. In this vein, surprisingly, while the 11th Circuit mentions recent 10th Circuit precedent, it does not mention Martinez-Perez v. Barr out of the 10th in 2020 discussed on episode 26, whereby, given the procedural history in that case, quote, it was within the BIA's jurisdiction to interpret the cancellation statute in a way that would not penalize the petitioner for the immigration court's delay, end quote. In that case, though, I think it was like a 6-year delay, and I think that most of it was due to immigration court backlogs and delays. But still, the legal principle remains. The 11th Circuit actually punted on Mr. Diaz-Arellano's related argument here that he should be accepted by all this because of undue and unfair agency delay, finding that even if such an exception exists, Mr. Diaz-Arellano didn't qualify for it given the procedural history here. So the argument still exists. Because while the majority is skeptical of the argument, hey, it didn't say no if the right case comes along. Check out Martinez-Perez v. Barr. And that is Diaz-Arellano v. U.S. Attorney General. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Moving on to Sustaita-Cordova v. Garland, published by the Fifth Circuit on October 31st, 2024. This case is about hardship and a lot of things. Kind of a theme this week. A lot of things. Mr. Sustaita-Cordova is from Mexico and entered the United States without authorization, and he conceded removability for that in removal proceedings. He sought LPR cancellation, apparently, because he's been here a while, and he alleged that his U.S. citizen child, Judith, would suffer the requisite exceptional and extremely unusual hardship if he were removed. He later sought to administratively close or to get a continuance so that he could pursue a U visa. That in turn was based on the fact that a law enforcement officer had sworn that he was robbed and stabbed in the chest in New York and was assisting in the investigation. Pretty horrifying. Seems that the IJ did not administratively close or continue the case because a full-on non-LPR cancellation of removal hearing went down, wherein Mr. Sustaita-Cordova and Judith testified. This is the point in the decision where we learn how all this really began. Mr. Sustaita-Cordova, quote, claimed it was his discovery of his wife's extramarital affair that led to his arrest for second-degree felony sexual assault of a child in 2016, end quote. According to him, when he told his wife that he wanted a divorce, she filed a false police complaint against him alleging that he had sexually assaulted another of their children. In fairness, the criminal case was eventually dismissed, and actually, quote, neither his wife nor the victim child testified at the 2018 removal hearing, and the wife did not discuss the criminal matter in the letter she submitted to the IJ, end quote. As to the hardship to Judith, though, it regarded her hearing loss problem that she'd had since birth, and the special schools and therapies and treatments in the U.S. that she receives. Plus, she needs surgery. Without it, she might lose the ability to speak. Can't get those treatments in Mexico, and Mr. Sustaita-Cordova can't pay for all of it if he's removed and she remains. So the argument goes. It was also argued that Judith's mother can't take care of her. She's the one who filed that police complaint, if you recall, and apparently she has a history of suicide attempts and mental health incidents. Apparently she also didn't help that much with Judith when Mr. Sustaita-Cordova was incarcerated pending the criminal matter. On the other hand, though, Judith currently lives with her mother and testified that she does support her. An immigration judge denied based on a lack of hardship and based on a lack of good moral character for Mr. Sustaita-Cordova. In addition to the sexual assault charge, the IJ noted Mr. Sustaita-Cordova's apparent failure to file taxes. Voluntary departure denied too. Administrative closure and a continuance for the U visa thing were not addressed. Things then got really messy on appeal, with deficient NTA arguments being made, a request for remand for a waiver attendant to the U visa application, a change of law favorably for administrative closure, and new evidence being submitted. The BIA affirmed the IJ and rejected the other attacks. To the Fifth Circuit it went where more changes happened. Mr. Sustaita-Cordova filed a motion to reopen with the BIA, for example. But also USCIS denied the U visa application. And then DHS physically removed Mr. Sustaita-Cordova to Mexico. Into this somewhat chaos the Fifth Circuit stepped and affirmed the BIA. First, the Fifth Circuit believed that some of the claims were now moot, but some of them can be reviewed, despite Mr. Sustaita-Cordova's removal from the United States. The U visa stuff was moot, explained the Fifth Circuit, although not before explaining that, at least if the U visa application was granted, I believe, most circuits have held that IJs possess the statutory authority to grant a U visa inadmissibility waiver. A legal question for another day that the Fifth Circuit has not yet addressed, but keep it in mind. Anyway, the denial of cancellation could be reviewed, despite the physical removal to Mexico. But here Mr. Sustaita-Cordova has a giant Patel problem. The Supreme Court's Wilkinson case saves review of whether agreed-upon facts meet the cancellation of removal hardship standard, but here Mr. Sustaita-Cordova, quote, takes issue with the IJ's factual findings, end quote. That's Patel territory. The facts aren't agreed upon, so the Fifth Circuit held that the issue was non-reviewable. While not reaching the issue, the Fifth Circuit does note in a footnote that some circuits have held that good moral character is also a mixed question of law and fact, a la Wilkinson, that can be reviewed, and that Oil was even conceding it here. So keep that in mind. But it would still, like with the hardship question, require that the facts be agreed upon, and that the only dispute be whether those agreed upon facts meet the legal standard, be it hardship or good moral character. Anyway, without hardship you can't win non-LPR cancellation, so that's gone. Recall the U visa was denied by USCIS, and in any event, recall, the Fifth Circuit deemed it moot in part because Mr. Sustaita-Cordova can apparently pursue reconsideration of that denial from abroad. That left only a deficient NTA argument, which every circuit has held does not have jurisdictional implications for the IJ and the BIA. To the extent Mr. Sustaita-Cordova argued that the deficient NTA violation is a mandatory claims processing rule that must be addressed, well, Mr. Sustaita-Cordova failed to raise it before the IJ, quote, prior to the close of pleadings, end quote, and so forfeited it. Essentially deferring to matter of Fernandez there, Fifth Circuit, without citing to Skidmore. Just saying. And that is Sustaita-Cordova v. Garland. I know you don't want to go and face the overwhelming stress that must be this first week of November 2024, but we must depart, and you must face the world. We conclude with Selden v. Garland, published by the Sixth Circuit on October 31st, 2024. This case is about immigration fraud and an immigration judge's duties in removal proceedings. Miss Selden is from Nigeria and entered the United States in 1992 using a passport and tourist visa issued to her sister. She lived and worked in Chicago and is the mother of 3 U.S. citizen children. 5 years later, she married a Mr. Selden, a U.S. citizen from Detroit, and they filed an adjustment of status application. That application was approved conditionally, given that they had not yet been married for at least 2 years at the time of submission. The couple jointly petitioned to remove the condition within 2 years as required, but at the interview, former INS believed that it wasn't a real marriage. When confronted with some inconsistencies, the couple apparently refused to answer questions, which INS deemed as abandonment or a failure to appear at the interview, meaning that Miss Selden's conditional LPR status was terminated. She was then placed in removal proceedings all the way back in May 2001 with 4 charges. Looks like former INS figured out the sister thing too. She didn't appear for that hearing and was ordered removed in absentia in 2002. Ms. Selden was not physically removed and successfully got her case reopened in 2011 based on a showing that she never received proper notice of the hearing where she was ordered removed in absentia. In reopened proceedings, Ms. Selden conceded removability but not the marriage fraud stuff, and indicated an intent to apply for adjustment of status, cancellation of removal, and voluntary departure in the alternative. The case lasted 8 years. By the time of the final hearing at issue in 2019, the husband had passed away. But Miss Selden had an approved I-130 filed by her U.S. citizen son, who by this point in the saga is over 21 years old. The thing is, though, that USCIS was in the process of revoking that I-130 based on a finding that Miss Selden's marriage had been fraudulent, making her 204C barred, it appears, from any future I-130s. Nevertheless, with the I-130 technically remaining valid at the time of the merits hearing, the IJ went forward, wherein Miss Selden testified all about the validity of her marriage and eligibility for relief as a matter of discretion. The IJ did not believe Miss Selden and deemed her not credible. The IJ then denied all relief. By this point, Miss Selden didn't have a qualifying relative for non-LPR cancellation, something we just discussed with that 11th Circuit decision. Stating that Miss Selden had, quote, no fear of returning to Nigeria, end quote, the IJ ordered her removed to Nigeria. New counsel appealed but didn't challenge the merits of any of it. Rather, counsel argued that the IJ erred in not advising Miss Selden of her apparent eligibility for an INA Section 237A1H waiver to waive the fraud, and that the IJ had violated the regulations by failing to advise her about asylum. The BIA rejected these arguments, and the Sixth Circuit affirmed. To begin, remember, the challenge here is in part that the IJ failed to comply with the Department of Justice's own regulations, or that is to say, the BIA's statement on appeal of what those applicable regs mean. That's Kaiser deference, not Chevron at the circuits, and so it technically remains alive post-Loper Bright. As such, circuits, quote, must thoroughly evaluate an agency's interpretation of an ambiguous regulation before giving any deference, end quote, whatever that means. Important because, pursuant to 8 CFR Section 1240.11a2, a non-citizen in a removal proceeding is entitled to apply to the IJ for a waiver of a ground of inadmissibility if he or she meets the statutory requirements. Under that same regulation, the IJ is under an obligation to, quote, inform the non-citizen of his or her apparent eligibility to apply, end quote, for such a waiver, and to, quote, afford the non-citizen an opportunity to make application during the hearing, end quote. The important requirement there, though, to the Sixth Circuit is that the non-citizen be apparently eligible, and Miss Selden was not for a Section 237A1H waiver, explained the court. Recall, the primary ground of removability here was that Miss Selden's conditional LPR status had been terminated when former INS denied the joint petition to remove the condition all those years ago. That is a different ground of removability than the ground that Section 237A1H waives, which is simply fraud at the time of admission. Now this is just me, but Miss Selden might have been able to file a new unilateral I-751 with USCIS requesting a waiver of the joint filing requirement, have that denied, and then pursue that in removal proceedings that were already ongoing. But she did not do so. As such, then, usually the only thing at play in removal proceedings such as this is whether that IJ, de novo, should grant the joint I-751 petition. And to be honest, under matter of Bernardo, which didn't govern at the time of the proceedings below, Miss Selden might not even be viewed as having an I-751 petition pending for the IJ to review, given that it was denied as abandoned or as a failure to appear. But let's put that aside, for now. As the court explained, the Sixth Circuit held in Hussam F. v. Sessions from 2018 that the, quote, fraud waiver operates to cure prior misrepresentations, not only the misrepresentation at issue in the most recent admission, end quote. Very interesting. Other favorable Section 237A1H precedent out of the Sixth Circuit as well. Similarly, of course, we have the Ninth Circuit in Vasquez v. Holder and the Seventh Circuit in Aqua v. Sessions, holding that a Section 237A1H waiver can be used to waive, quote, statutory grounds of removability not limited to being inadmissible at the time of entry or admission, end quote. In Vasquez, at least, I recall that means that you can pursue a Section 237A1H waiver to waive marriage fraud when connected to the I-751 process, at least when the I-751 is a joint petition. Even though the technical ground of removability is termination of the conditional LPR status, rather than a straight-up finding of fraud at the time of admission. It's very confusing stuff, I know. And if I recall, the BIA said you can't even do any of that in matter of Bador, episode 128. But of course, Bador is now owed no Chevron deference. Remember that. The Sixth Circuit itself actually went through everything I just said except Bador, but then said regardless, Ms. Selden couldn't even benefit from the Ninth Circuit's rule in Vasquez because her I-751 petition was denied as abandoned or because she didn't appear, because even though she did appear, she refused to answer questions at the interview. And that refusal to answer questions and then former INS's denial of the petition as a failure to appear, quote, is independent from the fraud itself. Although the letter terminating Ms. Selden's status discusses her untruthfulness, the final decision appears to rest on her failure to answer questions and thereby attend the interview, end quote. And yes, here is where the Sixth Circuit brings in Bador. It finds Bador persuasive. As good a time to mention as any on this very complicated week, before the Sixth Circuit affirmed everything, it quoted the Ninth Circuit's Lopez decision from episode 229, explaining that post-Loper Bright, we're in Skidmore deference territory now. That means that, now, precedential BIA decisions are, quote, not controlling, but may still have power to persuade based on the thoroughness evident in their consideration, the validity of their reasoning, and their consistency with earlier and later pronouncements, end quote. Seems to be where all the circuits are going to go post-Loper Bright, and the 11th Circuit kind of said that same thing too earlier in this episode. So matter of Bador is reviewed under Skidmore deference, a decision already agreed with by the Second Circuit, by the way, in Bador v. Garland, episode 220. Whether it's because the I-751 was withdrawn or abandoned, or because it's a failure to attend an interview to remove the conditional LPR status, that's an independent basis to deny a joint I-751, then is fraud, and so can't be waived by a Section 237A1H waiver in removal proceedings. Kind of like matter of Bador, but a bit narrower, I believe. Again, Vasquez from the Ninth is distinguishable, explained the Sixth Circuit, because even if that was the law in the Sixth Circuit, and the Sixth Circuit panel here isn't sure, the joint petition there was terminated due to a marriage fraud finding. Not the case here. Similar with Aqua out of the Seventh. My head is spinning. How about you? So then on to the IJ's failure to advise Ms. Selden about asylum. Well, her counsel never objected to the IJ's comments toward the end of the hearing that a fear-based claim hadn't been presented. The IJ even asked Ms. Selden through her counsel whether there were, quote, other applications she's going to file, end quote, and counsel said no. At a minimum, quote, once her attorney disclaimed relief, we do not fault the IJ for failing to advise her of it anyways, end quote. Be careful, attorneys. All of it meant to the Sixth Circuit that the IJ had no duty to advise Ms. Selden, who was represented, by the way, about a Section 237A1H waiver because she wasn't apparently eligible, or about asylum. Roller coaster of a case. Until next time, if there is a next time. And that is Selden v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.